because in the end, you pick the person over being right.
Plaintiff Christina O'Donnell is the only plaintiff who purports to state a claim of invasion of privacy, public disclosure of private facts, and false light. Ms. O'Donnell is a public figure who inserted herself into this public controversy of the missing child from Tennessee. She herself is a podcaster who goes by the handle Chasing Crime. Invasion of privacy is a complex tort that has 4 distinct causes. Oh, by the way, I want to back up and say one thing before I go on with this. Did you notice that basically it feels like these plaintiffs are operating under the illusion, or trying to give people the illusion, that they can just go to a court, make a bunch of complaints in a disorganized fashion, and expect some sort of relief. Expect that the court will pick through it, do their case for them. It's the same as expecting to be able to just come on the internet, sit there, fall asleep, and expect donations. Expect people to pay for your life while doing nothing yourself. You just expect to sit there and everything get handed to you and go your way. And they represent it that way to their audiences. And I just hope people know, when you get to the courts, you're in the big leagues. When you're taking your files, you're in the big leagues. You're going as real life as possible, because the outcome could very much harm the person that you are frivolously suing. So accountability is a major issue, and understanding of how the world works is another very, very big issue with these plaintiffs. In the complaint, Plaintiff O'Donnell alleges specifically that certain actions violated of sections BD of the restatement, intrusion upon seclusion, appropriation of name or likenesses, and publicity given to private life. The paragraphs relating to this count state that defendant Trudy invaded Ms. O'Donnell's privacy by disclosing private facts, that by disclosing those facts, they placed Ms. O'Donnell in a false light. No paragraphs in the complaint prior to those set forth in Section 10 with respect to the civil claims for invasion of privacy, public disclosure of private facts, and false light contain any facts that specifically support these claims. And the only quotes contained in this portion of the complaint allege that defendant Trude called Ms. O'Donnell a couch potato or a drug addict. The paragraphs in this section, and I just want to remind you that when Barbecue was here earlier, she said she never said those things. And there's no big whoop with calling somebody a couch potato. It's a little bit more of a whoop to call somebody a drug addict. But if you have a reason to believe that, then you're not defaming and you're not being malicious. The paragraphs in this section of the complaint allege that defendant Trude generally invaded Ms. O'Donnell's privacy by disseminating information regarding her sobriety, her history as a human trafficking survivor, and that she had lost a child. There are no specific facts contained in this count or elsewhere in the complaint which demonstrates to the court that defendant Trude disclosed any specific information about Ms. O'Donnell. There was no allegation of the dissemination of any medical records, drug treatment records, or any other private records. As with all prior sections of the complaint, plaintiff fails to identify with any specificity the sections of a YouTube podcast in which these purported statements were made, or what the actual statements were. In sum, Plaintiff O'Donnell has failed to establish the essential elements of a claim of invasion of privacy and or cause of action for this count upon which the relief can be granted. As such, defendants are immune from civil liability for this claim under Pennsylvania anti-SLAPP statute, and the claim must be dismissed. Last, the court addresses the fact as noted here and above, that the complaint identifies At Night Media LLC in the caption and in the identification of the parties, but makes not one factual allegation by or on behalf of At Night, nor does it assert any count or claims against any defendant in this plaintiff's behalf. Therefore, there is no claim by Plaintiff At Night Media LLC as a matter of law. Similarly, and also noted previously, the complaint identifies Dwayne Dog Chapman in the caption and in the identification of the parties, but makes not one factual allegation or claims by any defendant in this plaintiff's behalf. Therefore, there can be no claim by plaintiff Dwayne Dog Chapman as a matter of law. With respect to plaintiff Hong Zhu, all purported counts against the defendants in the complaint are criminal in nature. Further, the purported count under the criminal statute concerning endangering the welfare of a child relates to the missing Tennessee boy, not plaintiff Zhu's child. Therefore, this purported cause of action fails as a matter of law. Don't use missing kids' name for frivolous lawsuits to be a law pest. Okay? Once again, wait a minute. Similarly, the complaint alleges counts on behalf of plaintiffs Zhu, Jackson, Griffin, and O'Donnell for violations of section blah blah, the criminal section of the statute, prohibiting cyberstalking a child. Once again, the allegations in the complaint regarding purported cyberstalking pertaining to the missing Tennessee child, not any of the specific plaintiff's children. Therefore, these claims fail as a matter of law for this reason as well. In sum, the court is constrained to agree with the defendant's summary. Although the text from Plaintiff Mathis, so this is the court basically stipulating to everything that was written by one of the defendant's lawyers, okay? This is so humiliating and so humiliating for Lesniak, the way this ruling played out. Listen, in sum, the court is constrained to agree with defendant's summary. Although the text from Plaintiff Mathis is clarifying in its brutal honesty, we don't need to prove that this lawsuit is precisely the kind that this legislature sought to curb. The complaint itself has all the hallmarks of a SLAPP. It's 83 pages, 350 paragraphs, and 300 pages of unattached exhibits. The complaint utterly fails to adhere to the most basic rules of pleading in the state, forcing the defendants and this court to wade through its nonsensical claims to decipher the nature of the allegations against the plaintiff's claims aimed at defendants' right to free speech to allege. Fail to allege of any kind of requisite particularity the content of the actual statements made, despite the fact that many, if not most, of defendant's statements, as plaintiff's counsel admitted to during oral argument, are recorded. Pennsylvania's anti-SLAPP statute provides that a party may move to recover attorney fees, court costs, and expenses of litigation under Section 840, blah, blah, blah. Defendants Trude and Sinks requested an award in their anti-SLAPP motions. Pennsylvania's anti-SLAPP statute is clear that if, as here, a court finds that a party is immune under Section blah, then the court shall reward the immune party attorney fees, court costs, and expenses of litigation jointly and severally against each adverse party that asserted the cause of action. In light of the court's findings herein, including but not limited to that the defendants are immune from civil liability for the claims attempted to be pled in the complaint, the court must grant the defendant's request for such an award. While Pennsylvania's anti-SLAPP statute does not preclude punitive damages, this court declines to reward such damages at this time. That could very well change after, and this is my own edification, that could very, very well change after the hearing. In light of the foregoing findings and analysis, it is hereby ordered and decreed as follows. Defendants' motions pursuant to blah, 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 to dismiss the causes of action asserted against them based on the defendant's protected public expression immunity are granted. The complaint is dismissed in its entirety with prejudice. Plaintiffs are responsible and jointly and severally for and shall pay defendants' attorney's fees, court costs, and expenses of litigation and costs as required by blah, 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 by the court, Kelly D. Eckel, judge. So there you have it, you guys. I don't know. I actually think that people, with prejudice, choo-choos, mommy, with prejudice. So that any of these people believe that they could get a different result somewhere else, not only is in literal insanity, but it shows that they brought this case to be a sex pest, to do lawfare, to totally frivolously, completely vexatiously. And I think the way the court just, obliterated every single argument that they tried to make. I mean, they obliterated it. In most court rulings, you'll see the court agree with one or two of the losing party's arguments. They'll say, "Oh, I consider this argument and it's a good one, but here's why you don't get it." Or they grant, they say that on this cause of action you win, but on these other cause of actions you don't win. This is a judicial slam down. This is, and they didn't take it lightly, obviously, because it's precedent setting, not lawmaking, but precedent setting. So there you have it. I hope the plaintiffs remember this before they attempt to use the courts more frivolously. They're just going to continue getting the same result again, which is literal insanity, and you'll not only lose in the court, but you'll lose in the court of public opinion, because people don't like law pests. We don't like law pests. Here's your, and just for the super chats that I received, Here's another reminder of a law pest.
Grounds.
But the ultimate, I mean, this woman is the definition of a law pest.
I don't understand, since both of you do true crime and you follow court, how either of you think this is proper.
Doing this, right, because it's mentally stressful, right?
So then I have to shut down the internet.
I'm sorry.
And that's the same thing. The same thing applies. Any judge who's going to hear any of these cases and sides with a plaintiff who's taking one of these people to court is going to just have to shut down the internet to make them happy. So anyway, that's about it. I'm just looking through chat to see if there's anything specifically